5 minutes for rebuttal.
My Lady, Counsel Emily, first initial H, standing for submission of rebuttals for the appellant. The respondents rely solely on separation of powers. My Lady, I would like to remind my fellow friends here that the doctrine of separation of powers divides the institutions of government into three branches. One is the legislative, second one is the judicial, which is clearly defined in the Constitution of Fiji. In a democracy, no individual or group has absolute power to govern. These three groups work within defined areas of responsibility so that each keeps a check on the actions of the other. So when the government fails to apply or enforce the law, the courts step in to remind them of their obligations. Section 4, Chapter 1 of the Constitution states, this Constitution shall be enforced through the courts to ensure that A, laws and conduct are consistent with the Constitution, B, rights and freedoms are protected, duties under this Constitution are performed. No doubt that the government has ratified laws such as CEDAW into their National Action Plan. However, it is not effectively enforced. For nearly 35 years, my lady, I'm going to stress this again, 35 years, women rights organizations have been promoting gender equality. 25 years of CEDAW being ratified in Fiji, yet the statistics are increasing day by day. We appreciate the government's effort in creating and ratifying laws on gender issues, but it will be of no use if it's not put into practice. That is where the courts come in, from a social perspective, to remind the government of the day of their obligation to international laws such as CEDAW. The argument from my learned friends that the High Court was right in its discretion to not preside over the issue due to separation of powers is discriminating against women in its basic sense. Maybe our learned friends don't know that Fiji has ratified CEDAW and has in fact incorporated into our domestic law. My lady, my learned friends has also miscalculated that issues pertaining to national crisis could be adjudicated by courts. I need to remind this honorable court again that 64% of women, I'm going to stress that percentage again, domestic violence in Fiji, and that's a huge statistic. We are taking a social perspective using the justiciability doctrine. Also, my learned friends mentioned about floodgates. When the government is not doing their job properly, it will surely open floodgates to cases as such. There is a small gate for sure. If the government who is elected by the people are against them, there will be floodgate to such litigation. 49% of Fiji's population is occupied by women. My lady, counsel humbly submits that my fellow friends have also miscalculated on the grounds that the appellants are asking the court to compel the government to allocate money on gender issues. I would like to remind this honorable court that we are not asking the court to compel the government to allocate money on gender issues. We are simply asking if the courts could remind the government of their obligation to the international laws, such as CEDAW, which Fiji has ratified. I would also like to bring the court's attention to the Constitution of Fiji. The preamble, people of Fiji, recognize the Constitution on the supreme law of the land that provides the framework for the conduct of government in all Fijians. The government commits themselves the recognition and protection of human rights and respect of human dignity. My lady, if the government of the day fails to recognize the fact that gender issues must be is discriminatory. Constitution as such is made for the people and by the people. And if the government of the day is overriding the laws, the supreme law of the country, then that's absurd. Thank you.
Thank you, counsel. Counsels for the state, you have 5 minutes as well. Only 5 minutes, counsel, for about.
In response to what the appellant has already submitted, first of all, let them be reminded that this court only argues on the issues of law and not facts. That's the first. On the case of Garcia versus Bani Marama, we hereby submit that it is irrelevant to this proceeding on the basis that that case simply deals with the doctrine of necessity, not doctrine of separation of powers. In terms of the government's allocation of budget, they have raised that what has the government been doing in trying to